Welcome to the Agent Legal Lounge, the ultimate interactive weekly webinar that answers your burning real estate practice, contract, and legal questions. Hosted by distinguished attorney John George, co-chair of the Texas Real Estate Commission Broker Lawyer Committee, CEO and General Counsel of Special Provisions, and managing member of George PLLC. Tune in each week for an exciting, laid-back, and incredibly informative hour as John explores the Texas real estate profession, tackles hot topics requested by brokers and agents, and even takes your questions live. Get ready to dive in. The Agent Legal Lounge starts right now.
I hope today what we developed for you can help provide a simple guide on how to understand the agreements, how to recenter ourselves back away from all this legalese and all the lawyer language to what are these provisions actually doing. And so we encourage you to, Kiersten and I will be going through the slides and several discussion points, but we really want you to be involved. Put your questions in the chat, raise your hand. We want to make this a discussion today because we've been through it so many times. We don't know if we're covering all the bases that you might be thinking about. So feel free to raise your hand, jump in, put it in the chat, and we'll, with that, jump right in. Kiersten, do you want to say a few words before we get started?
Yeah, I'll just say that, the one thing you as we discussed through today, that you have to keep in mind is that there are decisions that your brokers have to be making right now. We can give you insight about the forms available to you, but ultimately it's your broker's business model and your broker's policies and procedures that you have to keep in mind. And one key question that I want to have John weigh in on or elaborate on is sharing compensation or sharing commissions. So go ahead and walk us through your thoughts on that.
Sure. So we all know that brokers are required to have written policies and procedures. It's built right in 35.2 of the TREC rules. And a lot of brokers use Texas Realtors model procedures. If you don't know they exist, they're out there. They provide a good basis for brokers to follow. Brokers should really analyze it, not just adopt it and run with it. But you'll see on your screen now the section out of that model manual. This is out of the current model manual, and it's regarding sharing of commissions. And it requires all the agents under a broker to get written approval from their broker regarding any sharing of compensation. And so the brokers are the ones that set these policies, set these procedures. And as agents, we need to make sure we understand what those are. And so in brokers, you need to make sure your agents understand they need to come to you to get that guidance. That is something that is a broker responsibility, a broker action, and really is benefiting everybody to have clear procedures. The one concern I have on this, if for the brokers out there, the independent contractor agreements generally allow, if you use the Texas Realtors form, agents to sign the commission agreements on the broker's behalf. So before they do that, you want to make sure you set the bounds of what they're allowed to sign, what they need to come to you to get approval for, what your internal process will be that really matches up how you operate. And so I see the question from Hillary in the chat. This 2.2.2 is out of the Texas Realtors model brokerages and procedures. These forms are available to brokers, and it's Kiersten, is it $99 for I think the cost to purchase that form? And then once you purchase it, brokers, you keep that. It gets updated. You don't have to buy it multiple times, multiple years. I believe it's once you buy it, you have that available. And it's a pretty extensive document that really sets a foundation of what a broker's at least minimum policies and procedures should be. And then you can modify from there for your own particular circumstances. But that's what that document is from. So with that said, everything we're going to discuss today is a method of how these provisions work, or how these provisions work at the end. Ultimately, your broker's the one that will decide how they're used and how you're allowed to use it in effectively making a contract between the broker and the clients, right? So that's what all these are. This listing agreement is a contract between the broker and the seller in that case. So what I've done here on this screen is to say that the next step, after you talk to your broker, let's understand the listing agreement. This is out of the TXR 1101. This is the residential buyer tenant, the actual title, residential real estate listing agreement, exclusive right to sell. I always like referencing both. So some people know it by number, some people know it by name. And the first step is to decide between you as the broker and the seller whether you're going to offer cooperative compensation to the buyer's agent. And to set the stage there, cooperative compensation is out of the listing broker's pocket. So they're getting paid by the seller and they're giving up some of what they're getting paid. This isn't concessions at this point. Concessions or contributions are out of the seller's pocket directly to the buyer or the buyer's agent. So in this case, we're talking broker to broker. So in this, we're looking at paragraph 5. This is where all that confusing language is. And today I really want to I'll answer any questions or things about the specific language that we'll highlight. But I really want to focus on the meaning of these provisions and highlight some of the little things in there that you might be able to look to better understand it. So once that decision's made, are we going to offer or not offer cooperative compensation to the buyer's agent? You have to decide whether to choose either 5A or 5B. So you see one at the top, I've highlighted and say pick one. So the first step there is deciding which one you're going to pick. And if you notice on the left, the blue box there is everything you need to fill out, which we'll go through in a minute, if you're going to offer the compensation. If you're not, as a listing broker, going to offer cooperative compensation with the authorization of your broker or client, then you fill out the 2.2 there on the B, which is that red box at the bottom. So the first step is really looking at this provision and saying, do I go with option 1 or option 2? And it's a real easy yes or no in terms of whether that broker to broker compensation is being offered. So keep it simple at the beginning. Just know which box that you're going to try to fill out or that you have to fill out in the next step.
Okay.
Kiersten, before I go to the actual filling out, what are your thoughts on that?
So the issue that I'm seeing in practice, or the disconnect, I should say, is that listing agents are filling out their listing agreement and they may be selecting 5A where they're choosing to share brokerage, share compensation. So that's in their listing agreement, it's signed. But the disconnect is that they're not communicating that information to buyer's agents when buyer's agents inquire. So I want to just talk for a minute about the fact that this is, number one, first, a brokerage choice on whether they're going to share or not. And then if you choose to go that route, the seller is making choices. So can you talk about a little bit about the seller choices and how, as the brokerage, we need to execute?
Sure. So it all goes back to our client. We're a fiduciary. We have fiduciary obligations. These discussions and how we market, how we disclose the amounts to buyer's agents or buyer brokers really needs to be seller driven, client driven at the end of the day. And if we're nervous about picking up a phone and telling a buyer's agent when they call what the cooperative compensation is, that's understandable, but we need to have thought about that in advance. And we need to tell our seller, here's why I'm concerned. Really think about it. Why am I concerned about telling the other side? Is it that I'm unfamiliar or not up to speed yet on exactly what me telling them means, the contract that may be formed by that discussion? Is it that I'm not sure my seller actually wants me to disclose it at that stage? So I think if it's thought through on where the concerns arising. Yeah, under my agreement, the seller's agreeing to pay cooperative compensation, but I just don't know where to start that, where to just throw it out there to make it firm. Before we had the MLS, it was easy, right? The MLS in the vast majority of cases listed the cooperative offer of compensation. We didn't have to try to find a point in time to either disclose it via the first phone call to the buyer's agent to say, no, we'll go look at the house first, all of that now that we have to think about needs to go back to the beginning though. When we first talk to the seller, when we're filling out this agreement and decide to select the 5A, that whole blue box there on your screen, we need to have that discussion with them saying when agents call, that's when here's the reasons why we should disclose it then. or we're going to disclose this on our website, right? It's going to be on our website. If buyer agents call in, we're going to direct them to the website that has the legal terms around it, right? Maybe a little bit more developed than just a phone call. There's lots of reasons to think about that too as a broker up front, because the one thing I think that shocks a lot of people is broker to broker agreements do not have to be in writing to be enforceable. Let that sink in for a minute. Broker to broker, agent to agent agreements do not have to be in writing to be enforceable. You know, we think of when we agreements between brokers and agents and buyers and sellers, that needs to be in writing for the broker to be able to collect a commission, right? We have those rules in place that say if you don't have a written agreement that's signed by the buyer or seller, you cannot go after them for a commission. But that same rule exempts broker to broker transactions. Right. So when we're offering cooperative compensation, it's really important to get that clear up front. And it goes back around again to where we're at here, having that discussion with the seller and telling the seller, here's how I'm offering it. And it needs to be clear so the parties know going into it what the actual agreement is. Right. So if you're going to tell them on a phone, I'll go ahead, Kiersten.
Well, I'm just going to say, so what's happening, what I'm hearing from, I'm actually sitting in a classroom with people now. And we're talking about seller and conversations we're having with sellers, and sellers are saying, you know what, I'll offer something. I'll offer concessions or compensation, but I want to see the offer first. I want to see it with the offer. So can you talk about the option 5B and how that relates with the other form, seller's authorization form 1412? Can you talk about that situation where the seller says, yeah, I'll consider offering something, but I don't want to lay all my cards on the table right out of the gate?
Mm-hmm. Yeah, so there's multiple options in that scenario. And I think we'll probably circle back around to really drive this point home at the end of the presentation. We have a few short slides to go through. But that's a good negotiation point, right? That's discussing with the seller, when is it most beneficial for us to disclose this? Is it up front to get them excited and into the house? Or do we want to look at the finances more? Do we want to see learn more about this buyer, learn more about the others that might be interested before we lock ourselves into paying a certain amount? And under 5B, that's the red box at the bottom, the seller's not agreeing up front to pay any amount in cooperative compensation. And I think I want to kind of move this to the back end a little bit, because the next one really highlights the misunderstanding about netting of fees and exactly how much is the broker getting under 5A. Because under a lot of circumstances now, 5A and 5B match up. It's no longer the case that we had in the past that listing brokers would keep the entire amount they put in for their compensation. Right? If there was, whether there was somebody that popped up on the other side as a cooperative agent or not, we always kept the same amount. We never decreased the amount that we would be entitled to. And so it's really important to understand that part, which is on this slide. So this, I'm going back, if you use these materials, this is the step 2.1. We're offering cooperative compensation at this point. And so we go to step 2.2. Well, what does that mean? And there's lots of different documents out there, some that are long, confusing. I try to simplify this as much as possible. So unlike the first thing we look at, where you have to choose either 5A or 5B, once you're within 5A, so we chopped it down now, we're only looking at that box of 5A. It stays at the beginning, fill in both, right? There's confusion out there whether you fill in just 5A1 or 5A2. It highlights there that you have to fill in both. So you have to fill in 1 and 2. The first box, if you see there in that blue arrow on the right, I put in there, that's meant to put in the total amount of that is going to be paid to the broker, which includes any cooperative compensation. This is the total amount the seller is going to pay under this agreement. The second box there in red, that you see in the red arrow, is it's only the amount that you as a listing broker are going to pay to the cooperating broker, to the buyer's broker. And so, but that's already included in 1, right? So that 1's the total amount, the total of everything. And then the number 2 is just a subset that from that number 1, how much are we going to offer the buyer's broker? So those are, if you look at those two boxes independently, you fill in both, those are the numbers that go in. Then we have some language here that if you look at right underneath the blue box in between the blue and the red, there's some legal language that's thrown in there. And then at the bottom in green, there's some more legal language that impacts how this actually works. But I try to simplify that on this chart. That if you look in the green arrows down at the bottom, if there's no other broker, which essentially means an unrepresented buyer on the other side, or it's an intermediary transaction, the listing broker is keeping the full amount in section 1, right? That's that amount up there, the total amount. That's the impact of that language, legal language that's thrown in there. The other situation is when there is another broker involved. And that's that red text at the bottom right there. When another broker is involved and the arrow points at that legal language that makes this happen, the broker's only keeping the net amount, the difference between 1 and 2. So you have the total amount, you have in 1, you have the amount that you're offering to buyer's broker in 2. Well, you have to subtract the 2. You're netting it. And the listing broker's only keeping the amount. That's the difference. Now, Texas Realtors' justification for this, if you read, they've come out with a lot of guidance, and recently there's a 5 or 6 page, written description of kind of a narrative style. They have some flow charts on this, but what's the reason for that? Well, the reason, at least that they state, is that you're doing more work when there's not another broker involved. Whether you're an intermediary and you have people on each side, agents appointed on each side, whether the unrepresented buyer, you're going to have to tackle more tasks on behalf of the seller. In that case, then you reasonably should, under the justification, keep more of the commission or the compensation, which would be the total amount. But when somebody is on the other side, you're not being compensated for that additional work. So they're saying that's only the amount in 1. That's what we're going to, the amount of 1 subtracted by the amount you would have paid somebody else. So you're only keeping that net amount, and the other part is shared with the other side. So I'm going to circle back one last time. And when you're within 5A, so we started here, and all these slides we'll make available. This will be posted on our website. You can print this out as a guide. I can email it to you if you wanted to have it by email. But here, so we're within A. You have to make a decision, go with A or B. Once you're within A, you fill it all out and follow the steps. 1, 2. Those are simple explanations, total amount not being paid to the side, and then the actual factual scenarios at the bottom of what it actually means in that provision. So it makes sense to my lawyer brain, but I get wrapped up a lot in this stuff, and I look at it so much. And Kiersten, does that help me make sense? Kiersten's great at saying, stop being lawyers.
We're going to keep it rolling. So here's 5A, 1 and 2 is the 1-lane highway you've always been on. What's changed a little bit is that if there's no other broker involved, then you're going to reduce what you are collecting. Now, John, now is where you want to talk about if there's an intermediary option, but that's one we need to talk through that and then move on to 5B.
Yeah, so let's tee up 5B real quick, because 5B is fortunately simple, right? 5B, you're not offering cooperative compensation. So the amount in 5B is just the amount that your seller's compensating you as a listing broker. There's not this complicated, crazy formula here. It's just, what amount am I being paid as a listing broker? And then any amount of cooperative compensation will need to be done some other way, authorized some other way, or there's contributions that can be done hopefully pretty soon in the TREC contract if those proposed changes go through with the adding that seller contribution field for broker compensation, or the 2406. There's an ability to do it, but we're in the listing agreement now. And when there's only listing agent compensation without this cooperative compensation, it's super easy in B. So what about intermediary situations? What you see on your screen now is in the 2406 section E. And this is the confusing form. And I'd say the guidance that I see out there, I haven't seen complete. And it's leaving off, I think, a little segment of how this can be used. But in addition, I think helps it be more understandable. So what's the problem with intermediary transactions to begin with? Why do we need this section in 2406? Well, let's say the easy scenario, we have 240, we have section B, 5B, which is seller has not agreed to for any cooperative compensation at all. Well, let's say somebody in the same brokerage, an intermediary transaction pops up, and the buyer wants to have some of their fees paid. Well, and the seller's saying, I'm willing to do it. There's a couple different vehicles to accomplish that, and this is one of them in the 2406. So what it says there, and this is one where I think it's actually helpful to read the language. In addition to any fees, seller has agreed to pay listing broker in a separate written representation agreement. Well, what the heck is that? Right? Well, that's either 5A1 or 5B. Right? That's the amount that seller's agreeing to pay the listing broker. So it can be in either one of those sections, whatever is chosen in paragraph 5, whether 5A or 5B, that's the one that's the amount that the seller has agreed to pay. So we start there. That's what that first half sentence means. And then, so if they've agreed to only pay, and for the 5B scenario, the listing broker not pay anything, well, this gives the seller the ability to then pay some amount towards the buyer's fees. Because they already have a cap on how much they're going to pay the listing broker in the listing agreement. Well, this says, I'm going to pay you a little bit more, listing broker, to cover the other side's representation fees that they've agreed to pay you. So it acts just like a seller contribution or seller concession in that sense. If we get away from the legal stuff, it's just like the seller offering a concession in the contract. They're agreeing to pay some amount to the other side. But this is the legal language that's needed to establish that arrangement and that agreement with the listing broker, right? So it makes it clear in there. If we look at the when to use scenarios, I guess. Let me go to that next step. When to use these. Let's get out of the legal language, when to use them. Scenario 1, we just talked about when B of the listing agreement was used, because nothing's been agreed to pay to the other side's fees, and the seller wants to pay some of them. Right, so that gives them the vehicle. Scenario 2, when 5A is used, right, so we have 5A, and seller wants to pay more than they've agreed to in 5A2. Right, that's another scenario I don't think you're seeing out there very much right now. But let's say they agree to pay X to the other side, towards the other side's fees in 5A2, but they're going to pay more than that. They're willing to pay Y now because of the negotiation. This is a provision that can be used to make up that gap. So we know when to use it or when it can be used. What's the purpose? It allows the seller to pay some or more of the buyer's fees to the same broker, right? We're an intermediary here to the same broker. And it ensures that the seller understands the payment of buyer's fees are in addition to the amount that's already stated in the listing agreement. So this is where it's providing notice. Now, I would say that the notice, this is confusing, right? So whether they actually understand it, but if you can explain it to them that way, hey, this is making sure you've already agreed to pay me X, you're agreeing to pay more than that now. And this is the amount that you're willing to pay more that goes up in the blank there. And this is too something to study up front and not get bogged down on the twisting of the legal language, but really understand the meaning and impact of it before you have the conversation with your seller. And then the seller is going to be just as confused, not having read all this stuff. So really focus on what in terms of the broker to client contract is, what the meaning of it is, and be clear in that. And I see probably a whole bunch of eyes glazing over and rolling on this. So I know it's easier said than done, but hopefully this will give you at least some kind of guidance on some meaning of the meaning of these provisions. Kiersten, somebody asked me throw it there. This is also straight concessions, not just BAC in addition. So so on here, this is going straight towards the buyer's fees. Now in the buyer rep agreement, we've agreed to credit any amount we get from the other side, right? So and they're getting it credited straight towards their fees. And so if you look at the proposed TREC contract changes, there's a provision that says this amount's going straight towards the buyer's agent fees. It's not lumped in with all the other available concessions. So that's why it's specific here, and it'd be specific if those TREC changes go through.
All right, any questions? Anybody want to raise their hand? All right, so I want to just clarify a piece. Because I want to tell you what I've seen, and John, maybe we tell a couple things that we've experienced this week. I experienced this week a brokerage, a broker sent one of their agents to me to ask a question, and in the listing agreement, they had selected both 5A and 5B. It says very clearly on the form to only pick one. So be careful about that. The other thing is I'm hearing from buyers agents that listing agents are not willing to share the information. They'll say, so this is how it plays out. The buyer calls the listing agent says, yes, the seller will cooperate, they'll pay compensation, but they will not hand over the form either 2402 or 2401. And so I just want to mention that if you fill out 5A, you've got to take the direction of your seller and provide that information. So if your seller does not want to offer that up front, you need to look at 5B and the option of using the form 1412, where the seller authorizes us to communicate what they want us to say. For example, seller will consider concessions or compensation conditioned upon acceptable offer. So you really need to know the intent of what your seller, the choice, number one, that your brokerage has made, whether to share compensation or not. And number two, what your seller is choosing. What is the seller's choice? And John, you want to give any insight and elaborate on 1412?
Sure. And just to tagline what you just stated is we have an obligation as is under the realtor ethics rules and just as a general under the TREC rules of being clear and concise in our agreements, right? And ensuring that they're understandable. The one thing about these broker-to-broker agreements is they need to be clear and concise, and hopefully in writing using the available forms, 2402 or if it's a concession, 2401. But the problem is as well as a seller, if you're you need to know how much is going towards the buyer compensation, because that could net out your number a different way. Because if you're using 5A1, remember you're not as a listing broker collecting everything if there's a broker on the other side. And if they're not getting the full amount your seller's willing to offer, that's going back into your seller's pocket. It's not going into your pocket as a listing broker. And so that impacts their finances. This 1412 form here is an authorization. So that the TXR 1101, the listing agreement, has a general authorization for you to advertise the amounts of the cooperative compensation. It's on the second page, right after the big paragraph 5 page, right? So it's a new paragraph on the following page, and it states that you can generally let people know that you're willing to provide cooperative compensation, but there's no blank for an amount. This form allows you to advertise a specific amount to inform buyer's agents that call in a specific amount that the seller is willing to consider to offer towards the buyer's expenses, whether that be a seller concession, whether that be cooperative compensation. This gives you cover as an agent in really making sure that it's clear between you and your seller, or excuse me, you and your seller, that here's what I'm going to do. Here's how much I'm going to let people know that you're willing to consider. And just remember, this isn't binding. This is not binding the seller. This is and I highlight there and quote it, and it's just they will consider it. Until a firm agreement's made, until they get it in writing, this document's only allowing you to say that they will consider that. So when you have those conversations, you need to make sure you tell buyer's agents that this is what my seller's willing to consider. Use those words. Don't say this is what my seller is doing or will do, right? Because that's more of a firm bullet point. They'll consider that and send over an offer. Send over the 2401 or the 2402 or put it in all these other forms. This is something to make sure your advertisements, what you're saying, is pre-authorized by the seller. And it differs a little bit in that it has that specific amount as opposed to the paragraph in the listing agreement. That's just a general advertisement that the seller's willing to consider those items.
Okay, I see Peggy has a question and we are at 11:31, so we've about covered it. Miss Peggy, what you got?
You can unmute if you like to, or see if you get it in the chat, or if anybody else wants to jump in, feel free to jump in. A few extra minutes here. We always like to respect everybody's time, and we'll see if anybody has that. I guess can't get Peggy's off mute.
Well, that tells.
These.
Go ahead, John.
Yep. And so if you email, you can email me at jgeorge@specialprovisions.com. Put that here in the chat. All this recording will be posted on our Facebook page. It'll be posted on YouTube, and we'll post the slides there as well. So I see a few more hands over here. Maybe take one question. I know Kiersten's in a class and teaching right now, so I want to respect her time as well. But
Yep,
Michelle, did you?
Let's get. I think Kim was first, just to keep it first come.
Okay. Yeah, let's do it. Jump in, Kim. Oh, still on mute.
All right, there we go. Better?
That is.
Okay, perfect. So regarding the 1412, if the seller has not given us a specific amount that they would consider because they just want to see the offers, and they are not authorizing us to disclose any other information such as seller's negotiable or bring all offers or whatever, do we need to include 1412 as a part of our listing package?
So if you already have if you're using the Texas Realtors 1101 or one of the other Texas Realtor listing agreements, it has that general authorization in there. And so in that case, you would not need to have the 1412 signed because you already can generally tell buyers and interested parties that general statement. And as well, this is somewhat of cover, and it's good cover for everybody to understand what you're exactly doing. So I would highly recommend using this form to the extent that any specific amount will be said to the other side. That just makes it clear for all. But to answer your question, no, don't. If you are using Texas Realtors listing agreement and you're just generally telling people that they'll consider it, you don't need this extra form.
Okay, and I'm going to put my broker hat on. The broker in me says I want that form.
Yes.
Because it's just extra clarification. It makes it very clear what the seller wants me to communicate. So I like the extra protection just of exactly, hey, we had this conversation, you acknowledged we had it. And so that's why I highly recommend that form. All right, Michelle, what you got?
We can leave that blank. We can leave a blank.
So I don't like blanks in general. That's my personal preference, but it doesn't have to be filled in with any specific amount in negotiable or something. You can put some word in whatever, something in there. I wouldn't leave it blank though to be subject to, well, there's another version that was filled in that's hanging out there.
I never leave anything in a contract blank. I always hit the space bar in zip form. That's a trick, right? You got to know to hit the space bar to be able to freeform type, and you hit the space bar and then type NA.
And to Kiersten's point too, the bolded points aren't necessarily included in the listing agreement language. So we have the seller, there's a little bit up there. So, but it does make an extra point is bolded, and you can never have over disclosure and over, telling your seller things in here. So I do agree with that sentiment. Michelle, I think you're next.
Okay, so quick question. If we're using 5B and I'm charging X% is my fee, but I want to address what happens if I have an unrepresented buyer, I want to charge Y. How do I best handle that in the blanks that are provided in the 1101?
So 5B doesn't have that distinction in there, right? So 5B is just what we're going to be paid with nothing to the other side. If you want to have the additional hurdle because of the justification that I'm doing more work here, this is the amount of additional work I'm doing. There's not a clear way to craft that in here because of how the language is drafted. The one is when there is compensation for the other broker. and it has that netting effect. But unfortunately, in the situation that you're describing, it will take additional language that you will need to draft up front. And you can, as a broker, highly recommend getting through legal counsel to help make sure it's buttoned up. But
Okay, John, you're sounding like an attorney again, right?
I know, I got it. It just makes me nervous when we talk about special provisions.
I know. Go back to the 5B slide for me. So on the 5B slide, B1B, Michelle, is now I'm going to back John up, okay? Because the directive we've been given from the TR attorneys is that we can use B1B. But I'm going to go back, even though I just scolded John, I'm going to say I highly recommend you have an attorney on speed dial for language that you want to start just, writing up in here. And I would probably have, as a broker, say, my agents need to come talk to me before they start getting creative. So I do agree that it's wise to have an attorney review.
Okay, perfect.
There's not ready crafted language for that in there. You can have it drafted and plugged into the policies and procedures. In that situation, your agents are allowed to put this in there or have that form available for them. But just make sure it's fully thought out, and I would be consistent across transactions when you do that as a broker. So it's not just written in by agents as they come up with language to fit a particular deal. And so that would be a blank that additional language could be inserted for sure.
Perfect. All right. Thank you.
Okay, Tori, like you're up next.
Yes, so I understand how the intermediary is paid out per the listing agreement, but if all parties within the brokerage, buyer broker, is agreeable with what the listing broker, who's obviously the same broker, is offering, then really we don't need to use 2406 at all. Is that correct, or am I looking at that wrong?
So let me see if I can pull up, Kiersten, you had that handy where we can put it on the screen, the 2406 language. I have it here.
So I think I can answer your question, Tori. So if it's intermediary and you used 5A in your listing agreement, it's addressed in paragraph 5A, number 4. Go to that number. You were there. See where it says number 4, that last sentence, it says seller and buyer, that's intermediary, or buyer is unrepresented. Amounts specified in 5.2A will be applied towards any fees a buyer has agreed to pay. Because remember, when you opted for intermediary, you had to have a listing agreement signed, a buyer rep agreement signed, acknowledging that they were able to participate in intermediary. And then I'm sure you use the notification of intermediary. So that last sentence says, fees a buyer has agreed to pay broker, because you had that buyer rep agreement, as specified in a separate written agreement. So it's going to apply the money here to that to satisfy. Okay. So you don't need 2406. It's 5B when you have when you only had in your listing agreement that you as the listing broker were going to be paid. And so if you selected 5B, this language is not in there, and I kind of wish it would have been included in our listing agreement under 5B, but right now it lies within 2406 on the addendum regarding broker fees.
With the tagline though, this language it's not limited to just 5B situations, right? That's what it's generally being used for, but there will be times when the seller is not offering the full amount in the listing agreement as cooperative compensation that ultimately they're willing to pay in a particular deal. So it can be, when we go back to this slide, and I was trying to get the 2406 total language there, but this has the relevant provision for intermediary. It can be a situation where in 5A1, they've only agreed to pay X, but now in this deal, they're willing to do more. And so you can make up the gap by the use of this form. And so either when 5B is the total amount they're going to offer in addition to for that buyer compensation, or the difference between what they've already agreed to offer in the additional amount that they're now in this particular transaction willing to offer for the 5A1 purposes. So it's a little more expanded than I think I've generally seen out there that it could be used for. And I have seen those situations arise already.
All right. I think we got it. I think we covered it, John. Any other burning
Yeah,
questions?
well, yeah, we'll tee it up for, so your opportunity. We love doing this. Kiersten and I always say geek out on this stuff, and we just love talking about it and helping out and instructing. So let us know too for future episodes what topics you'd like us to cover, and we try to stay current on the issues that are at hand that we're seeing in the market. But we need your feedback to know what you'd like to see. So we'll have all this posted. And Kiersten, thank you again as always. Really appreciate your help, and we'll do it again next Thursday. Take care.